Welcome to the fifth installment of Gowling WLG's M&A webinar series, M&A in Uncertain Times. Today, our panel will discuss the impact of COVID-19 on M&A activity in certain jurisdictions around the world, with a particular focus on the UK, France, Dubai, and China. If you missed any of our prior webinars in our series, including those on preparing your business for sale, dealing and on deal dynamics arising out of the pandemic, to name a few, the on-demand versions are posted on the Gowling WLG website. But before continuing on, before we get started, a number of housekeeping points. To view the presentation and all speakers, please click on the speaker view in the upper right-hand corner of your screen. For questions throughout the session, please use the Q&A button at the bottom of your screen, and we'll try our best to answer some of your questions at the end of the session. And you should feel free, rather, to reach out to our team afterwards as well if you have any other questions that we can answer. The presentation will be recorded and posted on our website in a few days. And this program counts for 1 hour of CPD credits. So for those in Ontario, for example, 1 hour of substantive credits towards the mandatory annual CPD requirements of the Law Society of Ontario will be allocated. Also, we have our legal disclaimer, as you can see. Today's session is a high-level overview. It's for specific advice. You know, we encourage you to contact your legal counsel in your local jurisdiction. And as you know, the situation is extremely fluid and changing daily. Continuing to our panel, today our panel is comprised of Barbara Jufa, a private equity and M&A partner in our Gowling WLG Paris office. We also have with us Chris Towell, a private equity M&A and indirect real estate investment partner at Gowling's WLG UK offices. Tim Casman, who's the leader of the corporate team and managing partner of the Gowling WLG Dubai office. And we have Peter Zhang, the leader of Gowling WLG's China initiative and a partner in the Toronto office. My name is Nurhan Aken. I am a partner in the Toronto office and practice in the areas of M&A, corporate finance, and private equity. And I also head up the Turkish country desk. I will be moderating the discussion today. Continuing to our agenda, for the remainder of the hour, we'll be comparing and contrasting deal dynamics and the social and economic impacts brought on by the pandemic on M&A transaction in key jurisdictions around the world. Specifically, our panelists will be exploring the following trends in the countries where they work and the differences in those trends across those jurisdictions. We've narrowed down to kind of 4 topics: the effect of COVID-19 on transaction timing and mechanics, as well as contractual and diligence issues. Second, issues relating to valuation. Third, employment and labor issues, particularly in the context of the reopening of businesses as various jurisdictions are opening up around the world. And lastly, foreign investment and changes to applicable regulatory regimes. Of course, as much as possible, we want this to be an interactive session. We would love to have your questions at the end of the session when we'll have a chance to go through them. And now just turning to topic 1, my first question for the panelists to set the stage and provide some context is that, you know, we want to ask about the transactions that have been worked on recently. How has COVID-19 affected the transaction flow and the process for completing the transaction? And what contractual or diligence issues should buyers and sellers be mindful of in negotiating and closing M&A transactions in the current context? We are trying to build on the webinars that have been previously posted. And so what we're trying to do is not go back to those topics that were covered previously, but to add on and build on it in the international context. But having said that, I wanted to start with Chris Towell, who is in our UK office, and wanted to hear from him with respect to this question. Over to you, Chris.
I mean, I guess it's probably a similar pattern for all of us in all of our jurisdictions at the moment. In that, from an M&A perspective, it's certainly in the UK, and I think in Europe and I'm sure elsewhere, activity is sharply down over the last 6, 7, 8 weeks than we would usually expect to see at this point in the year, this point in the cycle, or indeed that we were seeing before the COVID-19 situation came to be quite as significant as it is at this moment in time. So all significant M&A transactions that we were working on in the UK, other than those which are genuinely strategically important for clients for a particular reason to continue with have either gone on hold, rarely aborted to be fair, so rarely gone off, but gone on hold, or at least significantly slowed down. So those transactions which are proceeding at a, honestly, a snail's pace, not just a much slower pace, with both parties really feeling around, trying to work out what's going on, looking after the essential points in front of them in respect of both their businesses in the meantime, and largely waiting to see what might occur over the coming months. On a broader basis, we see most of our corporate clients pausing their transaction activity for now whilst they reserve their cash position, protect their business, deal with the multitude of other issues that this situation has brought to their door in respect of their existing employee situation, business situation, contract situation generally. From an investor perspective, a private equity investor perspective, similar activity, to be honest, pretty much paused overnight whilst those private equity investors look at their existing portfolios, make sure those existing portfolios are as well looked after, during this period as might be the case, and now starting to, with a degree of confidence, I think, plan for what might happen in the coming months, i.e., as we turn the corner, as sadly some businesses are up for sale because of a new distressed position that they find themselves in, perhaps looking for additions to those portfolios to strengthen those portfolios. So I think deal flow at the moment very slow, deals that are proceeding very slow, but confidence still there in the market at large that this is we would hope, temporary, short, sharp, very, very painful, but temporary process, which people are already starting to look to the opportunity for, as we come out the other side of it. In terms of the impacts on the transactions themselves, I think the key impact is really just the timing implications for those transactions. So both investors, buyers, sellers alike are not in a rush to transact unless they really, really need to, unless there's a distress situation or a particular reason for pushing the transaction through at any pace. In the main, people are slowing right down. Obviously, things like due diligence are far more challenging when you can't get out and about in the same way that you ordinarily would do. We'll talk shortly about valuation implications, but the CV-19 situation has clearly impacted almost all businesses in one way or another. And at the moment, whilst we're in the middle of it, it's difficult, I think, for sellers as well as buyers to have a genuine handle on that, and therefore what the implications might be in terms of a sale process today and the ongoing management of the business going forward. So in the main, longer periods, but longer periods by agreement between both sell side and buy side, because there just continues to be uncertainty.
Yeah, I agree, and I've been seeing in our LOIs that we've been entering into that exclusivity periods have been longer, just to take into account the difficulties around due diligence and getting to the root of that, as well as we get to our discussion on valuation, trying to get a handle on the impact on the financials and the cash flow positions of the various businesses. Peter, let's turn to China. What's happening in China in this context?
Now China has opened up, but there are still some special COVID-19 measures. So I think I like to give my observation on special due diligence requirements in terms of special COVID-19 related measures implemented by different jurisdictions. So one example now in China is even the country is reopened, but for tracing the infection contacts purpose, personal health QR code on cell phone is used everywhere to monitor the virus infection. So people is required to report travel history regularly on cell phone application. So the application updates each person's QR health code daily by giving a color. So green means these people has no travel history in the last 14 days out of city, no close contact with infected case. So it's a certificate of safe. So yellow or red may mean alert. So almost all venue now in China, they check health code before admitting people in. So even recently opened the Disney park in Shanghai, they check people's health code before admitting them in. So also before boarding a transportation vehicle, you need to show your health code. For international travelers, they ask you to download an international version of your health code. So I think for mergers, acquisition, for due diligence, as part of a due diligence process, special attention should be given to this kind of new measures. So in terms of China, we have a corporate team there, so we can help client do the most updated due diligence and advise the client potential impact of special measures. So another observation I'd like to give is related to the flow of transactions from China. So here in Canada, we still see Chinese investors coming in to do acquisitions, but they put extra conditions for closing, and the closing period is extended. A recent announced transaction is about TMAC. It's TSX listing mining company. The buyer is a Chinese public mining company. It's called Shandong Gold. The Shandong Gold has entered into an arrangement agreement with TMAC to acquire 100% of TMAC. So in this deal, so they put in a closing condition that Shandong Gold should have access to the mining sites of TMAC. So TMAC's mining site is in Nunavut, Ontario of Canada, and another one in Boston, US. So this is rare from my experiences. So the other special clause is the extension of a closing period of this deal. So in this deal, they put in 6 months plus 3 months extension for closing. So compared to other 2 similar transactions, those two are 4 months plus 2 months. So this closing period is unusually long. So I think that's the party's reaction to potential impact of COVID-19. Yeah. So that's my observation from China perspective.
Activity have such a long closing period and then have a separate extension period. Tim, let's turn over to you. What are you seeing in the Gulf region?
Yeah, it's interesting. I mean, very much similar to what Chris has said, really. You know, obviously the impact here is in some ways no different from the impact that's happening all over the world. There are obviously, the situation is incredibly fluid as it is everywhere else. A good example of that is 2 days ago, Saudi Arabia announced that they're increasing VAT from 5% to 15%. And clearly that's going to have a very dramatic impact on sort of F&B, retail, etc. The UAE have come out and said that they're not intending to increase VAT in line with that, which is great. But it really is a good example of the impact that sort of government intervention can have in the current times. There are a few nuances here, unlike other jurisdictions. So insolvency laws here are slightly less developed in some ways than they may be in, for example, the UK or Canada. And that has an impact where you have distressed sales and distressed businesses. So what you can't do in the UAE is have a pre-pack situation where you can effectively revive a company easily out of administration. And there isn't that short, sharp administration process where you have an acquisition immediately afterwards. And that's a considerable issue, obviously, in distressed times such as these, because it just doesn't give the opportunity for many of those distressed companies to come out the other side. The other big issue is payments, and that's quite a considerable issue across the whole region. And that obviously impacts from cash flow. So if you are looking at acquiring in this region, the debtor book and due diligencing that properly is going to be very important. And realistically, you're going to need considerable cash injection as well. And I guess that kind of leads to structuring as well. So, you know, if you are going to have to inject cash for an acquisition, but for example, you're structuring it on an earn-out basis, you've got to get over that psychological hurdle that you're sort of funding the sellers or the company to pay out the sellers earn-out, etc. So that's a bit of a mind shift that people probably have to kind of think about. People also being pretty inventive here at the moment. So I've got a transaction on at the moment where a party really wants to exit a company here. It's in the events business. That business owns a couple of assets that have a significant value or should have a significant value in the future. So they're just exiting with a vendor loan and security over those particular events. So you're seeing some pretty inventive solutions to structuring transactions at the moment. I've got another transaction at the moment where people, one of the concerns is supply chain. So they're looking at sort of spare parts and issues around that. So that was a specific area of focus for them. And then overnight, actually, we've had an example of what we expect to see a lot more of, where the local franchisee of an F&B brand has turned around and said they just can't survive and want to sort of pull out of the franchise arrangements, and we expect to see more of that. So that's a quick overview of what we're seeing in the Gulf.
Yeah, thank you. Clearly, there's
No, Han, we're struggling to hear you, actually. Sorry.
Is that better? Okay. So clearly, there's opportunities in the Gulf region, and it goes without saying that the question that comes up is the next topic in terms of valuation. And so the purchase price is a significant issue on the mind of buyers and sellers in the corporate transactions, obviously. And the value of the business generally will be no doubt impacted by COVID-19 in one way or another. What key valuation issues are you seeing, and how are the parties to an M&A transactions addressing that uncertainty in purchase agreements that you've seen so far? Chris, why don't you take this question on first?
Thank you. I guess from my perspective, so I completely agree with you. Valuation issues are coming to the fore already, as you'd expect. I think really we face two issues within M&A transactions in relation to two broad issues in relation to valuations at the moment. Issue number one being how do we value the businesses at the current time or going forward? Do we take into account the impact of CV-19 or not? And issue number two being, depending on where we get to with that, how do we share the risk of getting that wrong? So in relation to the question on how we value, I think probably we're all of the view that there will not be, or there's very unlikely to be, very many businesses who have been completely unaffected by the CV-19 situation. So in some cases, we'll all have clients who actually are doing really very well out of the situation because they're essential businesses for one reason or another. Maybe they're in the supply chain to an essential business, maybe they're delivering foodstuffs, whatever it might be, and they have seen a significant spike in activity as a result of the CV-19 situation. Probably more likely are the number of clients who have seen a decline in their current activity levels as a result of CV-19, whether that be because they've had to close down operations for a period, or work in different ways, or just because people aren't out there buying their products, shopping in their shops, whatever it might be. So in the main, one end of the spectrum or another, all businesses really will have been affected at least to some degree, some very significantly, some less so, as a result of this period. And likely that effect, hopefully it will soften with time, but it's not going to stop overnight. These businesses are not going to go back to normal. There will be, for many of them, a new normal, which may be better. They may have streamlined their businesses, they may have not, they may have found new ways of working, better supply chains, whatever. But clearly they will not have the same consistent track record of financial records that they might have been able to present 3 months ago, that would have shown a consistent behavior, a consistent type of track record in terms of turnover, profit, and the rest of it. So the big question is, from both the buy side and the sell side, how do we treat this period? How do we treat the coming months? Do we just pretend they didn't happen? Do we exclude them for the purposes of valuation? Maybe there's an impact on the cash reserves in a company because it's used some cash up. Maybe there have been some short-term costs when it comes to closing down a manufacturing plant or reopening one, more likely. But how do you value that? The reality is lots of conversation around that, but so far as we're seeing really in relation to deals at the moment, no particular consensus. Obviously you can argue it from both sides, and indeed there are always two sides to a transaction. So, nature dictates that probably either party is arguing that from the opposite position and hoping if CV19 has given their business a boost to take that into account, whereas obviously the buyer would suggest that it's an anomaly and shouldn't be. If their business has been suffering, if you're the seller, you're going to want to suggest that actually it's a short-term thing and shouldn't be taken into account. At the moment, in the main, excuse me, what we seem to be seeing is people largely agreeing that we should slightly wait and see. We've got longer, as we've already discussed, slower, drawn-out sale processes typically. So there is time to gather better information. This has been such a short, sharp situation so far that it's very difficult with any certainty to judge the longer lasting effects of this situation on any particular business. So yes, we can all say you've had a difficult time, you've closed down for 6 weeks, there will be costs of reopening, there might be employee costs, there might be, reduced operation for a period because of social distancing, whatever it might be. But it's very difficult to, without a crystal ball, without that benefit, predict what the ongoing effect on a particular business will be. So in the main, I think we are seeing people slowing things down, looking to gather better information, take either a more risk-based approach, because in a few months' time it'll be more obvious because the particular target business will be in a more difficult situation, and therefore the buyer will have a better bargaining position to assert whatever position it wishes to assert, or indeed the business will be performing on a more consistent basis and it's easier to make a call that way. In very few cases are we seeing one particular side of that coin being imposed strongly over the other, unless there is a fairly traditional, bargaining position that's being utilised to one person's benefit or the other. In terms of how the risk sharing is addressed, depending on where you get to with that valuation in the first place, to be honest, at the moment we're seeing fairly typical approaches to that in discussions, i.e. should there be some form of slightly more drawn out, slightly more sophisticated completion accounts process or earn out process, or other type of deferred consideration. And again, typically the normal arguments are applying. So of course, if you're the seller, you'd rather get paid fully day one. If you're the buyer, you'd rather de-risk for a period and require that there's evidence of the business performing to a certain standard before you hand over the rest of the cash. So far, those conversations are not yet getting, apart from in particular strategic business acquisition cases, not yet, I don't think, getting to a point where we would see them to be particularly different trends to the norm. So yes, people are more focused on those situations, but again, I think largely because of the slowed down, more drawn out processes we're seeing, it's not as dramatic a problem as it might otherwise be, because we're just naturally not seeing the same turnover of M&A activity as we might, and therefore whilst these are very real problems, they're not quite as urgent as they might be, because in the most part people have got more time to think about it, plan, do some further investigation and due diligence in relation to the ongoing performance, and critically I think wait to see how and in what state the business is transacting as various jurisdictions start to reopen. Their marketplaces, commerce, factories are allowed to reopen, different workplaces are allowed to reopen. It's very difficult to make that kind of decision right now when so many people remain in lockdown and so many of those businesses remain mothballed. So far, I mean, that's probably not a super helpful answer, because no real magic or, kind of very whizzy technical solutions to the problems we face. But, in the main, I would say a very collaborative approach actually from both the buy and the sell side to being sensible, waiting to see, gathering more information and, hoping things become clearer as we progress.
Yeah, and one other thing we see is that on the valuation side, new things are being looked at that weren't historically looked at. For example, I've seen in a transaction I'm working on where we have considerations to supply chain now being looked at very carefully, and in fact looking at whether how difficult it would be to retool for just in case delivery of inventory as opposed to just in time, and local production versus just in time delivery, and the impact of that on a business and its valuation. So there are multiple considerations that are coming around as a result.
And on that point in particular, Nurhan, and that is a point that actually probably affects the UK more than most other jurisdictions at the moment, because one very, very small benefit that's come out of this process is we've all stopped talking about Brexit for a period of time. But obviously lots of UK businesses have been or had been starting to turn their attention to European supply chain issues. For example, do they need to nearshore in a way that they haven't done before? And this whole process has refocused people's attention on questions like that in a much more significant fashion. So, but out of that, for a number of businesses will come positives, right? People will re-engineer in a more efficient way and right size their businesses in a better, a more impressive and probably more profitable way going forwards. Possibly not for the majority, but in a number of cases, I'm sure.
Right. Peter, let's turn to China. What are you seeing in China in terms of this issue on valuations and
I think now the current situation with so many uncertainties, it reminds me my experiences in China years ago. So when the Chinese market is deemed as an emerging market, so for acquisition purpose, it's very hard to evaluate a target business because many companies, they don't have a long track record. So, and also it's hard to find good comparables in stock market. So at that time, to draw money from pockets of buyer, so buyer normally will ask to include an earn-out clause in the transaction agreement. So some even require the seller to guarantee the 3-year financial performance of the target after closing. And some even go further to ask the controlling individual sellers to provide personal guarantee to the performance of the target business. So this practice now is still popular there in China, especially for public companies because they have concerns to the impact of acquisition to their stock price performance. So, so that's why I think I totally agree with Chris. So we may see more price adjustment clauses in transaction agreements and like clauses like performance-based, earn-out, earn-in, even vendor take-back clauses. So, but on the other side of coin, I think the seller will have similar concerns to the financing capability of buyer. So will buyer be able to pay? So in this regard, so I like to share a good news in the Chinese market. So that's the reform of Chinese IPO regulatory process. So before the Chinese IPO process is an approval process. So the government took strict control to the flow of IPO. So the government approval process is usually slow. Sometimes it took 3 to 4 years. So I have a banker friend while waiting for his client's IPO application to be approved. He had 2 babies, not twins, with 1 wife. So from late last year, the Shanghai Stock Exchange, they opened a new board. It's called the Shanghai Sci-Tech Innovation Board. So it's like a NASDAQ in China. So now it has already 100 companies listed. So this board, they implemented a new IPO approval process. It's called the registration process. So the feature of this new process, the first feature is the significant speeding up of IPO review. So in this new process, the IPO candidate file prospectus and other documents to stock exchange, to Shanghai Stock Exchange. So after being satisfied with all the information disclosed, the exchange will submit the application to the Security Regulatory Commission for registration. So this process, on average, for the last around 100 companies, on average took about 4 months. So that's significantly faster than before. And the second feature of this new board, new process is they relaxed financial performance and the change of control requirements for IPO candidates. So before they ask 3-year profitable performance and no accumulated loss, and under similar control for 3 years. So now they relaxed all those requirements. So now 2-year similar control is okay, and they don't ask for profits anymore. So, and the third feature of this new process is the special voting rights. So we may recall in the year 2015, when Alibaba was considering where to do IPO. So it chose US instead of Hong Kong. At that time, many people, especially Chinese people, expected Alibaba will go public in Hong Kong first, at least first. But why not Hong Kong? They chose US because Alibaba's corporate governance structure is special. So its 2 large shareholders at that time were SoftBank and Yahoo. And the management founder team only hold minority shares, but they had special voting rights. So they had control to the company. So to keep the control to the company, so Alibaba chose US, New York Stock Exchange instead of Hong Kong, because at that time, Hong Kong, they didn't allow special voting rights. Their listing rules is about similar shares with similar rights. But Hong Kong reformed its listing rules, and Alibaba went back to Hong Kong to do second listing last year. So this is the third feature. The fourth feature of this new process is open to international companies. So international companies can issue CDRs. So it's called China Depository Receipt. It's like foreign companies to issue shares in US in form of ADRs. I think with this, now the Chinese government is collecting public opinions to the rules of this new registration process. I think the new process will be in force this year. So it will attract public companies to do listing, more companies to do listing to finance from public market. And it also will help international companies to exit from that market. So that's my observation I think with more liquidity on the market, it will help pricing and the valuation of potential transactions.
Yeah, it sounds interesting, Peter, and especially it gives the opportunity, I guess, for roll-up strategies connected to public markets in the near term as part of financing, some of these companies coming out of COVID. Now, I wanted to turn to our third topic now, which is on labor matters. When the pandemic struck, many businesses were closed or reduced their physical operations, with employees moving to remote working arrangements, such as ourselves. And then as now some jurisdictions begin to flatten the curve and reopen their economies, one of the key issues that businesses need to contend with is actually how to manage their workforce and safely return to work. Given that our panelist home jurisdictions are at various stages of recovery, we'd like to ask how their business environments are changing or preparing rather to reopen the considerations. I'm going to first turn to Barbara. And I know, Barbara, in France, you recently got some good news lifting your lockdown yesterday, in fact. And so what are your seeing in terms of employers' obligations to their employees and steps taken either now or in the coming weeks as the business is restarting their operations?
Well, France is always an interesting jurisdiction when it comes to employees. In France, employers have a safety obligation to take all necessary measures to guarantee and protect the safety, physical and mental health of their employees. And since the COVID, they already, I mean, before COVID, they already had to put everything down in a document, and since the COVID-19, they have to update it in order to assess the risk and safety of the employees. So, as you just said, Nurhan, France has just started to end its lockdown yesterday, and some of the companies have reopened. However, home office still need to be prioritized, and only employees that really physically need to go back to work will go back to work, actually. And we'll need to implement some measures that have been set up by the French Ministry of Labor. So in practice, these measures really depend on the type of activity and sector of the company. And they will include some of the measures that we have seen all over the world. So that is, for example, providing facial masks to the employees, encouraging them not to take some collective transport means, and do not travel if not really necessary. Rearranging the premises so that you don't have too many employees in the same office. So this is for avoiding all the open spaces. Trying not to take lifts. So employees shall really define also an action plan in case they suspect someone in the employees to be proven of contamination, such as taking the temperature check before they get in the building, and informing the employees' representatives in case of that. So I would say that tip number one would be for employers to cooperate with the employees' representative to avoid any claim, and to get written proofs of the written measures that have been implemented. Why do I say that? It's just because within the context of the COVID-19, we've seen that several trade unions have already filed complaints against very big companies such as Amazon. And Amazon was compelled to close its French distribution centers because they could not prove that they took necessary measures to protect the employees. So I would say that this is tip number one, really work in cooperation with you employee representatives. And tip number two, make sure that you've done everything possible to avoid any criminal risk or injunction. So which means get all the proofs you can on the measures that you have implemented.
Yeah, you talked about developing an action plan in the case of suspected contamination. And so one of the issues everybody's worried about is the recontamination or the restart of COVID-19 in workplaces, et cetera. What steps do you recommend that business owners take to mitigate that risk and avoid future claims and complaints? And I guess in the context of an M&A transaction, obviously there's a due diligence aspect to that as well.
Yeah, well, in case of an M&A transaction, well, I would say that first, the acquirer should check that the measures have been taken within the company, that they have talked with the employee's representative, and that they have sufficient proofs. In case of recontamination, well, you cannot really do anything right now to prevent that. The only thing you can say is that in case of someone contaminated, then you've done everything, which means you check the temperature, you ask him to come physically, we inform all the employees' representative and the employees that someone was contaminated in your office, and make sure that they also can be tested.
Mm-hmm. Great, thanks, thanks, Barbara. That's good advice. I wanted to turn to the Gulf region. Tim, what do you see in terms of labor and employment matters as things are opening up in the Gulf region?
Yeah, well, there's sort of a number of challenges out here. So I mean, obviously, in a tax-free environment like the UAE, it's not really possible or practical, particularly with the number of expatriates as well, to introduce furloughing or something similar. So there have been some real challenges for employers, and I guess for the government really, of how to deal with the situation. And what the government has done is they've introduced some legislation which allows, with the consent of employees, employers to reduce salary on a temporary basis. And there's also a sort of option for employers to request unpaid leave again if accepted. Some of the free zones have gone a lot further than that. So the DIFC, which is Dubai International Financial Centre, for example, have actually made it possible for employers to reduce arbitrarily, so without consent, salaries of employees and or put them on unpaid leave. So, I mean, that's a pretty dramatic change of legislation, although it is temporary. What we're really seeing, I guess, is more reduction of salaries. So people are trying to preserve jobs by reducing people's salaries. That's something that a lot of businesses are looking to do. So there is a desire, I think, a genuine desire to sort of preserve jobs rather than make redundancies. The other issue here is that there isn't actually a sort of formal redundancy law. So from an M&A perspective, that's something to be aware of. So if you're acquiring a business here, expecting to be able to restructure the labour force, while you don't have unions here, there isn't really a sort of redundancy protection either. So unless you can show a justifiable reason, the employee could have a claim for arbitrary dismissal, which would result in 3 months' pay being awarded, or up to 3 months' pay. And I guess the only real sort of benchmark we've got for that is what happened in 2009. And the courts back then came out in favour of the employees. So just because of the financial circumstances, it wasn't regarded that that was a justifiable reason for dismissing employees. So from an M&A perspective, that's something certainly to be aware of. The other issue and nuance here from an M&A perspective is accrued liabilities. All employees accrue an end of service benefit here, which is equivalent to, after 5 years, equivalent to 30 days salary. So that can be a significant accrual. And a lot of businesses aren't accruing that in cash, so there's no cash accrual there. So that's something to be aware of. There's also a requirement to pay repatriation flights as well. So there are a number of nuances here that you have to be aware of if you're looking at acquiring a business, and particularly if you're looking at acquiring the business, knowing that there does need to be a sort of restructuring of the employees.
Right. Thanks, Tim. I know the UK was unfortunately one of the regions hit hardest by COVID-19, and so I wanted to turn to Chris. What do you see in terms of the gradual reopening of businesses in the UK?
Yeah, well, I guess what we're seeing primarily is that it is a lot more difficult than the sudden closing of the businesses in many ways. So, you know, clearly a large number of corporates in the UK and, you know, large number of employers generally, as in every other jurisdiction, have been affected by the situation and have been required to find new ways of working. In some cases, that involves closing down entirely for a period. As Tim mentioned, in some cases, in a lot of cases, that's involved furloughing employees for significant periods already, and possibly in some circumstances significant periods to come. The government's just announced today in the UK that the furlough plan, the furlough scheme, is extended into October. So, you know, they're clearly expecting, up until now they've been rolling it out on a month-by-month basis, they're clearly expecting it's going to be necessary for certain parts of the industry. The reality is, I think, for most of our clients, that, you know, they reacted at a sudden point in time when they were required to do so, because, you know, the government told them that they needed to close their doors, send people home. If you could work from home, you could. Only a very small minority of people in, you know, certain roles were required or allowed to go out and do their jobs to some fashion or another. That, you know, shutting down is clearly difficult, painful, dealing with lots of employee issues. But from a corporate governance and risk perspective, I think opening back up in many ways is much harder. You know, there have been significant financial implications for employers and employees of closing down, but the ongoing risks associated with not getting the next stage quite right, I think, are probably more significant potentially from a corporate perspective. So I would say the two main issues we're grappling with, excuse me, are how, when, you know, at what speed, following what regulations do you reopen safely? You know, tell your staff to come back potentially into harm's way and do their job, you know, in an environment which is not at home with their family in a restricted social circle. how do you keep abreast of those guidelines, because they're changing on a daily basis, literally, you know, further explanation being provided at all times. And critically, and again from an M&A perspective, now or in the future, how do you demonstrate that you follow proper governance in making those decisions in the first place? Because, you know, as we all know, it's very, very different when you're looking back through, you know, a lens in 6 months' time and assessing whether or not the right regime was followed, the right decisions were made. So how do you set yourself up and mitigate your risk for that future scenario now when we're going through the process? I think you know, the situation is compounded and, you know, much more significant for international corporates where they're dealing with a number of different jurisdictions, operations in different jurisdictions. So as you know, Barbara and Tim have just demonstrated, there are very different rules in play in different jurisdictions, you know, different rules in play at different stages and at different paces in different jurisdictions. So our normal process, you know, from a corporate perspective, where decision making is in the main, significant decision making is usually relatively centralized to a degree, is difficult to follow in this kind of scenario. You know, it's not, you know, if you take a major US corporate with operations in 10 different jurisdictions, some of them in Europe, some of them in Asia, it's not really possible to make a corporate decision in the US and apply that on a top-down basis to the other jurisdictions, because each of those jurisdictions will have different rules and regulations, all of which are, you know, coming out at different times and changing in different ways, which you can't really hope to imagine unless you're talking to people on the ground, both from an advisor perspective and from an implementation perspective. So I think that, you know, the key point from a UK perspective and critically in relation to more global organizations or, you know, or transactions, is that you really do need to look at this on a local level, because the rules and regulations are not in any way, shape or form one size fits all. You know, lots of jurisdictions are looking to each other for guidance if they're ahead of each other on the curve. But that is guidance only. We're all facing different challenges at different times. So, you know, local advice, I would say, is critical. And you know, take it as read that you probably need up to the minute local advice because the situation is so fluid and constantly changing. From a general corporate governance perspective, and I think this feeds into ongoing M&A activity, I think governance and demonstrable governance, so being able to show that you went through a proper process at the time in considering how you should follow the regulations, how you should reopen, you know, what implementation steps should be taken, what safety steps should be taken, and the like, is going to be pretty important when you get to a stage in, you know, several months' time when, you know, in a positive situation, you're looking to buy or sell a target company which has been through this. In a negative situation, you're dealing with a potential claim from, you know, some other party who feels that they have been damaged in some way by your lack of proper process or procedure or activity. I would say a lot of our clients, you know, are necessarily global clients, as you'd expect, who are, you know, dealing with various jurisdictions, and they are questioning how they deal with their central decision-making process in a way which is seen to be appropriate. So I think from a UK perspective, there is no question that those decision-making you know, processes and regimes continue to be perfectly sensible and perfectly appropriate from a corporate perspective. But, you know, if on a local level it's possible to challenge that, because you can show that, you know, in the US or in Canada or in the UK, a decision was taken at a topco level and then enforced upon, you know, the subsidiary in France or Italy or Dubai or wherever it might be, without sufficient demonstrable consideration and discussion with the people on the ground that understood the local laws and, you know, were dealing with the implementation, the reality is you're in a much worse position to, you know, mitigate your risk and defend any such claim or demonstrate to a potential purchaser that you did things properly. And I think, you know, critically, we would all take this view as corporate lawyers, I'm sure. There is, you know, probably very few decisions which corporates take that could not be challenged to some degree at some stage in the future when we've all got a different view of the situation and better information. So what's important is that people show proper governance at the time and you know, genuinely do the best they can, look at the relevant information, talk to the relevant experts, and make a decision in good faith in the best interests of the company and move forward. I believe that actually most corporates, especially in this situation, are really actually trying to get that right, trying to do that faithfully for the benefit of their, you know, employees as well as their stakeholders, but keeping proper records of those decision-making processes on a local level is likely to be very important, I think, as we move into the, you know, the kind of the coming months and possibly years when we're looking back at this situation and, you know, God forbid, a claim has arisen because an employee has suffered harm, and you need to demonstrate that on a UK or French or whatever basis it might be, that you did not just assert and impose a decision from a different jurisdiction onto that local operation. So I guess those are the two key points that I think we're seeing coming out of this from an employee perspective. It is clearly a very, very difficult, ever-changing, fluid, and emotional, and important state of affairs that people are trying to deal with. Dealing with it centrally is nigh on impossible to get right. I think you definitely need to consider the local law issues, and you definitely need to consider how you demonstrate that you're taking those into account, having the right conversations and involving the right stakeholders.
Yeah, I agree with you, Chris. And in Ontario, we have a similar legislation where we have to, notwithstanding whatever the government may legislate in terms of working, going back to work, etc. Our primary obligation on employers is to take every precaution reasonable in the circumstances for the protection of the workers and individuals at a workplace. So, as paramount, that's the paramount objective. And so, I agree. You have to definitely look at local council and get their advice on how to do this effectively. And certainly it's going to be an impact in due diligence on a prospective target's ability to comply with those guidelines. I don't want to dwell on Canada. I know the firm has extensive resources on our website relating to employment matters, so I'm going to skip the Canadian piece on that. But I am going to turn to our last topic, which I think is quite important because varying jurisdictions have different reactions to what's happening with COVID-19. As you may have heard, the Canadian government announced that it will apply enhanced scrutiny to foreign direct investments in certain businesses and all investments by state-owned enterprises until the economy recovers from the effect of COVID-19. So, clearly the Canadian government is taking a view that there are valuation discounts potentially for Canadian businesses and will take a stringent view with respect to direct investments of any value, controlling or non-controlling, in Canadian businesses that are related to public health or involved in the supply of critical goods and services to Canadians or to the government. And in addition, as I mentioned, all foreign investments by state-owned investors, regardless of value, or private investors, will be assessed closely and tied to or subject to direction from foreign governments. Will have enhanced scrutiny under the Investment Canada Act. Again, we had a webinar recently where Ian McDonald of our office spoke extensively on this topic. But the long and short of it is that if you're doing a transaction that potentially fits in that bucket, it would be prudent for foreign investors to do an advance notification to the under Investment Canada at least 45 days before closing. But I wanted to turn to other jurisdictions. In particular, I think China is interesting. And so again, I wanted to turn to you, Peter. What are you seeing in terms of what the Chinese government is doing as a result of the COVID-19?
Me? Sorry, Nurhan.
Yes, go ahead, Peter.
Okay, thank you. So in terms of China, up to now, China hasn't issued any new restrictions or new measures to control foreign investment. On the opposite, China has relaxed its control to foreign investment by implementing the new foreign investment law. So that came in force on January 1st this year. So before all foreign investors to China, they are asked to go through a two-stage process. First, to get an foreign investment certificate. So in that certificate, the total investment, registered capital, names of investors, and scope of business are all recorded. So that means all those items should be approved, reviewed, approved by government first. And then they can register a new entity. So now under the new law, foreigners will have national treatment as local investors, except for business falling in the negative list published by the government. So all foreign investors now can register their companies in China as local investors. Before Chinese personal individuals, they cannot be a shareholder of a foreign invested company. So now this restriction has been canceled. So after incorporation, the new foreign invested entity need to file an information return to the government database. So before foreign invested companies, they register under 3 laws, like joint venture law, foreign invested enterprise law, and another law is called, I forgot the name of that law. So it's not under corporation law. So with this new law came into force, all the existing foreign invested companies, they have 5 years to transition to amend their corporate governance as complied to the general corporation law. So there is a 5-year transition period. So in terms of the negative list, there are 2 big categories. So one is called forbidden category. The other is restricted. So the forbidden list is not long, mostly include businesses like on defense or news media. So most restricted businesses are not only for foreigners, it's also for local investors. So only around 40 businesses are specifically restricted to foreign investors. So the Chinese government said it will amend the negative list. In the new 2020 list, the list will be shortened, and businesses like medical care, senior care, and training will be taken out from the list. So this is like a big change for foreign investment into China. So, but another thing I like to remind our audience is the China hasn't relaxed its foreign exchange control. So that means capital in or out of China is still need to be reviewed. So for example, if a vendor is a foreign company, buyer is a Chinese company, the target is foreign companies' corporate shares in China, in the Chinese entity. So only after the change of shareholder is registered, the payment to the foreign vendor can be exchanged to foreign currency and wired out of China. And also another big change, I think, is the finance industry. Before in China, the finance industry is restricted to foreign investors. So I think in late last year, in the process of US-China trade negotiations, China announced it will relax foreign investment into finance industries in China. So the deadline is April 1st. So there will be no any maximum limit to foreign ownership to Chinese banks, fund management companies, and securities companies, life insurance companies. So that I think from this change, we may see more M&As in China with foreign finance institutions involved. I think foreign finance institutions, they, for a long time, they like to expand their business in China. In terms of merger control, there's no change. So the existing threshold for notification of mergers are still the same. For parties, worldwide revenue is 10 billion RMB, and all parties' revenue in China is for each party's revenue in China is 400 million. And the other threshold is all parties' revenue in China exceeds 2 billion RMB. And each party's revenue in China is exceeds 400 million RMB. So there's no change. So in terms of the investment into China, so from legal perspective, there are no new controls.
Okay, thank you, Peter. It's clear the Chinese government's prioritizing measures to encourage economic activity and support the country's financial recovery. But not all jurisdictions are the same. Barbara, I know France is a little bit different. Maybe you can address the situation in France. I think it's similar to Canada, is not.
Yeah, well, France is completely different than China. I would say that we are more in a similar position than Canada. And the COVID-19 has immediately strengthened the French foreign investment regulation. So, for example, the criteria have changed. Before COVID-19, a foreign investment resulting in a change of control or an acquisition of a line of business, or if the investor comes from outside the European Economic Area, then you would have an acquisition of more than 25% of shares of or voting right of a company. You would submit it to the control of the French Minister of Economic and Finance. And that was for the following sensitive sectors. So you had defense, energy, transport, public health, etc. And since the COVID-19, so you have already friends that have announced that they will temporarily decrease the acquisition threshold that I just mentioned of 25% to 10%, in case the target company is listed and an investor comes from outside the European Economic Area. So this is exactly for the same reason that you were mentioning, Nuran, which is to make sure that foreigners do not take benefit of decrease of valuation of listed company in sensitive sectors. And the second action that France has already taken is that they have added in the sensitive sector a sector that you will think that is very obvious now, which is the biotechnology sector, in order to make sure that we have sovereign activities for biotechnology. And lastly, I would also say that the French Minister of Economy and Finance have publicly announced their refusal of transaction, which was an acquisition from a US company of a French company. So it's Teledyne wanted to acquire Photonis, which is a French company for night vision devices, which plays a strategic role in the French military industry. And French government declared that they cannot contemplate an acquisition by an American company, as this company shall remain sovereign, as they say, and that there was no debate in the refusal of such that really showed that there will be more protectionism, more scrutiny, and that it will be very difficult. I mean, not difficult, but we'll have a lot of to acquire a company in France if in sectors.
Thanks, Barbara. I know we're just over 2 o'clock. I think we'll probably be going to about 2:10, and then maybe we can look at some questions at that time. But before I finish, I wanted to get Tim's view, because I think it's important to hear what the regulatory environment is in the Gulf region.
Yeah, so I think the GCC has been looking to attract overseas investment for a while now, and there have been gradual changes across the GCC. So Saudi Arabia have recently made it much easier for foreign companies to have 100% ownership. The UAE is certainly looking at that as well. So they've introduced new laws allowing 100% onshore ownership. There is a restricted list, similar to Barbara alluded to in France, and it's the areas you'd expect, so oil and gas, telecommunications, financial services, insurance, etc. But the UAE is looking to attract foreign investment. One of the questions is, what can the GCC do to attract expats at the moment? There are a number of stimulus packages. There's a lot of effort amongst the free zones to reduce fees. The government's reduced trademark registration fees. They've also reduced visa fees, etc. So there's quite a lot of things that the government are doing to try and attract and continue to attract expatriates to Dubai. But there's no doubt that the UAE, being a country as it is, which relies on oil and tourism, is obviously going to suffer in the current climate. But as I say, they're very much looking to encourage people to set up. And if you're in e-commerce, for example, there's a great opportunity here. And there are a number of e-commerce companies that are doing fantastically well. So where there are issues, there are also opportunities.
Great. Thank you very much. I think it's all great advice. Before I turn to questions, just wanted to highlight our upcoming webinars. As you see in the slide that gets put up, that we have another one coming up in our M&A and Uncertain Times series next week, 1 o'clock, same time, which is M&A and succession planning. And then we're also launching a new webinar series, which is called Financing in Uncertain Times, which we would like you to invite you to attend. And that's for this Thursday. And then you can see the other ones that are in the weeks following. So we are out of time, and we tried to keep it to 1 hour, but we're just over. And I understand if people want to leave. It's just a reminder that the session's recorded and will be posted on our website in a few days. And then you can also reach out to any of us with questions, and we'll be happy to answer. And so thank you very much. We've appreciated the opportunity to discuss this topic with you today. And until next time, stay positive, stay healthy, and our very best to everyone. Thank you very much.